Okay, good evening, everyone. So I know we have a few more joining us, but we will just continue to let people in from the waiting room as they appear. But I want to welcome all of you who are able to join us tonight. We're thrilled to be here with all of you who were able to participate. We know that there are many registered participants who will be unable to join tonight because of the power outages and destruction caused by yesterday's storms. And I just want to start by saying our hearts really go out to all those whose struggles in this pandemic have only intensified as a result of the storm. We will be recording tonight's workshop and making it available to all registered participants. But this is also a time-sensitive issue, and we wanted to be sure to move forward so that people can begin to have this information accessible to them. As of Friday, the Iowa Policy Project, now Common Good Iowa, noted that unemployment claims have risen by about 427,000 in Iowa during the pandemic. Workers and advocates, our center included, have been flooded with requests for assistance in understanding unemployment claims, denials, and appeals processes. And we're very pleased to be able to host tonight's workshop to address many of the key issues that have been arising. For those of you who are not familiar with the Labor Center, I'll just give a quick background. We are the only unit in the Regents system devoted to research and education on Iowa workers' rights and policy issues that affect them. We were founded in 1951 and have 4 educators on our staff. In normal years, we travel across the 99 counties of Iowa to teach classes in workers' communities at times, and even in languages that are accessible to them, on legal rights and policy issues. Of course, this year we are hosting classes on Zoom, and will be for the foreseeable future until things change. Tonight, we are especially excited to present our guest instructor, Alex Kornya. Alex is the litigation director and general counsel at Iowa Legal Aid, and he has worked at Legal Aid since 2008. Primarily focusing on consumer protection, housing, tax, and collection of debt owed to the state. And Alex is really, I would say, one of the leading experts in this state on this issue. So we're really thrilled that he could join us tonight and share some information and answer some of your questions. So with that, I will not take up more time, and I'll pass it over to Alex. Thanks again, Alex, for joining us.
Of course, thanks for that nice introduction. So just a little bit, for those of you who don't know about Iowa Legal Aid, which is the nonprofit that I work for, we are a statewide law firm that provides free legal assistance, civil legal assistance to low-income folks, seniors, and veterans, new Iowans, and other vulnerable groups. We've been in existence since 1977. And so are coming up on our 45th anniversary, and existed before that in sort of smaller iterations of county legal aid programs going back to the 60s in 4 cities in Iowa. I would say that, you know, the amount, we closed about 15,000, a little over 15,000 cases statewide last year. We cover all 99 counties in Iowa from 10 regional offices. You know, about probably 5% of those cases were unemployment cases last year, which is way down from where it was during the last recession. I think we can start calling it the last recession now, maybe, or maybe I'm being too cynical at this point. Anyway, I'm a lawyer, so they force you to be cynical in law school. That's the first lesson. Try to find the dark cloud in every silver lining. So, you know, during the last recession, we probably did about 20%, anywhere between 15 and 20% of our cases during the worst times in unemployment. Over the last few months, unemployment cases have become about 30 to 35% of what we're seeing in new cases. So a massive increase. This is probably the #1 issue that we're seeing, followed unfortunately closely by evictions. And of course, the two are really just, one is the continuation of the other. It's a really huge problem, and we're facing, I think, unprecedented challenges with a system that is not really equipped to handle the load even in the best of times, and under the current demand is just not really doing what it's supposed to be doing. The other big challenge from a lawyer's perspective is normally lawyers look at the law, and we, make arguments based on law that is created in a transparent way, policies that are conveyed in a way that is constitutional, that follows certain types of basic legal protections for people, especially when law is being made by an agency who are essentially unelected folks. There are specific constitutional and statutory protections that balance the fact that sometimes law is made by people we never elected, with power delegated to them by the legislature. But usually there's a transparency to that, and we can sort of make predictions and make arguments. A lot of that really is not present under the current circumstances. So a lot of what we're going to talk about today, and the way I'm going to set this up, is we're going to talk about the way unemployment insurance works in normal times, and then we're going to talk about how things have changed, both with the federal legislation and some other, discernible policies on the state side. But we're also going to talk about some things that are a little murkier when it comes to policy. So just to sort of forewarn you, there's never any sure answers in the law. Try to get a lawyer to give you a yes or no answer on anything. I'm sure you've all experienced that. Very difficult to do. It's going to be even more difficult now, but we've seen enough of these cases, and we have some observations that we hope will be helpful as you deal with these cases yourself. And so throughout the presentation as well, I just want to make one more point before I get into things. So to the extent that you have a question that might relate to a specific case that you are working on, or a person that you're working with, or it could even be you, I cannot answer any questions that are specific to the facts of any particular case. It's a lawyer ethics thing. Can't do it. But what I could do is, if you could state it in a general way, and if you ask me a question that I don't think I can answer, I'm probably just going to change the question and then try to answer as close to what you're asking me as possible. But I can't answer any questions specific to your facts. Just that's one of the rules I have to follow. So with that, I'm going to go ahead but do ask questions, and don't hold your questions to the end. I'm fine with answering questions as we go along. I prepared a lot of material. We may or may not get through all of it, but I've front-loaded it with what I think is most important stuff. So if you have questions that come up, please do ask them. I'm here for you. Okay, so unemployment insurance in normal times. The most important thing we've got to do is sort of understand what the normal system is, the long-standing, venerable system of unemployment insurance, and then we can start to understand the changes that have been made and the new layers that have been added because of the pandemic. So basically, the basic precept of unemployment insurance can kind of be broken down into a sentence that itself can be broken down to a few ideas. And from all of this, from this one sentence, there is a ton of unemployment law and complexity and lawyering that has been done to make this a sort of complex area of law. But it all comes down to this. Unemployment insurance is income for workers who are temporarily unemployed for no fault of their own. So what does that mean when you actually apply it to the real world? Well, first of all, the nature of the separation of work has to be something that is not the worker's fault. So that comes down to really two different types of separations. If the worker has been terminated, it has to be for a reason other than misconduct. The law defines misconduct as an intentional act that someone commits against the employer's interest. A lot of the cases that Iowa Legal Aid over the years have involved the meaning of misconduct and kind of the level of intent. It's almost an analog to criminal law when you're trying to figure out the intent that someone had when they were committing whatever it is the state is saying that they did. It's very similar to that. There's an intent requirement to it. It's not just, somebody screwed up or even that they didn't follow instructions correctly. There's got to be some kind of animus there. If someone is terminated for misconduct, they're not eligible for unemployment because, going back to this initial concept here, temporarily unemployed for no fault of their own. Another reason why someone might be not eligible for unemployment is if they quit for something other than good cause. Iowa law says good cause attributable to the employer. That is not exactly correct, and I always push back on that when I hear it. It actually, in my opinion, if it was to be accurate, should say good cause that is not attributable to the employee. because a lot of times there are intervening causes that have nothing to do with the employer or the employee that lead to a quit that would constitute good cause, despite the language that was added to the reg, which I think is inaccurate, frankly. So we've got the first step, which is the separation from employment can't be for a reason that is the employee's fault, whether it's not good cause quit or misconduct. In addition to that, there also has to be there are a few other eligibility requirements, basic eligibility requirements. The first is the worker has to be able to work. In other words, not unable to do the job due to illness or disability or prevented by their condition from being able to fulfill the basic duties of the job. Now, of course, it gets a lot more complicated than that, but that's the basic idea. The second is they have to be available to work. In other words, they have to be able to fill the hours that they're supposed to fill. So, for example, if someone is not able to do a job because they don't have childcare, maybe because they can't get daycare for some reason, usually that person is considered not to be eligible for unemployment because they're not available to work. You have to be actively seeking work. That is, translates in most states, including Iowa, to a job search requirement, a weekly job search requirement. You have to accept work that is quote unquote suitable when it is offered to you. Suitable work generally means that it meets pay requirements and can otherwise be done by the worker without hardship. We'll get into suitable work in a lot of these things. We'll unpack a lot of these things later in more detail. You also have to be authorized to work in the U.S. when the services were performed and when you are eligible for benefits. The final point I want to make is that normally, under normal circumstances, unemployment benefits are a fraction of wages, of what someone was earning in wages from their last job or jobs. And that is because the normal idea is to encourage people to only be temporarily unemployed. And so policymakers generally have said, if you make the benefit amount too high, it will disincentivize the work search requirement. So normally just a fraction of benefit amount. It looks like I got a chat. I just want to check it here real quick. So some employees have had their hours reduced. At which level of furlough is needed to be eligible for unemployment? Is it a percentage of their full-time earned income, or a percentage of their hours reduced, or some combination of the two? So that is a good question. I think it depends on whether or not, if the person has never been fully separated from their job, and it's not a callback situation where they were laid off for a period of time, then I think it is going to be probably some combination of the two. We'll talk a little bit about suitable work, a slightly different situation where someone has actually been told, has been fully laid off and then brought back. After a certain period of time, their former employer can call them back and can actually bring them back at reduced wages to a certain percent, which is based off of a formula in the law. And under those circumstances, they actually wouldn't be eligible for unemployment for the wage reduction because of the suitable work requirements. I feel like I answered your question and then I answered a question you didn't ask, so I hope that wasn't too confusing. Let me know if you want me to go back to that or if you feel like I didn't answer that clearly enough. In the meantime, I will move on, but feel free to ask the question. I can always go back if something occurs to you based on what I've said. Okay. So another important thing to consider is how the unemployment system is funded. And so a lot of times you hear the terms charge to the employer, charge to the employer. Does that come out of the employer's pocket directly? No. It is something that basically I would think of it almost like an insurance premium, except for it comes in the form of federal or state taxes. And essentially, the more claims made on unemployment insurance for a particular employer, the higher those tax rates will go based on a statutory formula. And so for the most part, in normal times, this is important to remember because usually the unemployment system requires the employer to have some skin in the game and to have an incentive to appeal cases. Now we're going to talk about how that's kind of different now for a number of reasons, and it's created some weird permutations in the appeal system. But basically, it's kind of like a car insurance premium. If you get into accidents, then the car insurance premium goes up. If there are more claims made against someone's an employer's account for the purposes of unemployment, then there are going to be higher tax rates. I realize the lighting is very bizarre. It looks like I'm underlit. It's actually just the sun reflecting off my table. So sorry if that's creating a weird effect. It makes me feel weird to look at. So anyway, there you go. Another way that the unemployment system is funded, it's not talked about as much, although I think it should be, is clawback of benefits from the workers through overpayment collections. I would say that over the years, states and the federal government have become more and more aggressive about trying to turn these necessary benefits into debts that are owed to the state and subject to all of the kind of debt collection superpowers that a state does have. One of the things we were, had some disputes with our workforce before this particular crisis started was a move by workforce to begin collecting certain types of overpayments by offsetting people's federal tax refunds. And so we actually submitted some comments and were asked to write a proposed rule that we thought actually, was complied with federal law. And they ultimately decided not to adopt the rule or any rule, but they're still using that process. In other words, and there's lots of other ways in which they collect these overpayments. We're going to talk about overpayments too, because a lot of the people now who are kind of caught up in the system, especially people who were receiving benefits, and then all of a sudden got a notice several months in that said you're no longer eligible for benefits, are also facing potentially gigantic overpayments because of the $600 per week supplement that many folks received. So we're talking about tens of thousands of dollars that people might now owe to the state unless they are able to follow, to thread the needle and be successful in appeals and potentially other things as well too, as we'll talk about later. And then also in some circumstances, other tax revenue will fund it. But primarily the federal and supplemental state taxes on employers and then collection of overpayments, which was, I think, there are several billion in overpayments have been collected over the last few years. Okay, so I talked a little bit about this before, but in normal times, who makes the rules and how? Unemployment is kind of across an interplay between federal and state law. Federal law creates the basic structure of the program, and that's from statutes passed by Congress, U.S. Department of Labor regulations, and then what I think is really helpful to try to figure out what all that means in the real world, unemployment program letters. So these are basically letters that the U.S. Department of Labor puts together that explains the U.S. Department of Labor's idea of what the law is, federal law is, to all the states. So when the states are designing their own programs, this is what they look at to determine, whether or not they're doing it right and what their requirements are, based on, the people they have to answer to in many ways at the federal side of things. So I often find that these are very helpful to understand, practically speaking, how these things are going to be applied and just to know what the states are being told. So then on the state side of things, the states also enact their own state laws. They have some discretion to change the system. Iowa's system is not exactly the same as Illinois', as Wisconsin's, as Hawaii's, whatever. But there are certain federal laws that kind of create boundary lines. So states have some latitude to do things differently, but not unlimited latitude. They're constrained by federal law. There's also state regulations at Iowa Code 871, Chapter 24. These are regulations that were created under a process called notice and comment, which I sort of alluded to earlier, which is, when the legislature passes a law, you elected those people, so they're accountable to you, the voter. But if the workforce passes a regulation, we didn't elect those people. So in order to make that a law that passes muster under the Constitution, they've got to do something else to give the public some kind of participation in order to make that not just some kind of dictatorial rule. And so normally that's the way it works, is something called notice and comment, where the agency says, we think the rule should say this. And then people have an opportunity to say, that's great, or you know what, this is terrible, you should actually say this. So that's the way the rules are normally made. I'm putting all this out here because we're going to contrast that to what is happening now. Okay, so how has COVID changed unemployment? We're going to talk about the expanded regular benefits, which happened towards the beginning of things and ended at some unknown point. We'll talk about that. CARES Act benefits, and then also extended benefits. Okay, so right when it started to happen with the pandemic, there were three important events. The first one a little less important than the first, but I like to mention it. So the first is on March 12th, the U.S. Department of Labor issued one of those unemployment program letters I talked about, which is guidance from the U.S. Department of Labor to all the states saying this is what you should be doing to implement unemployment in your state. And in this letter, they basically said, to the extent that many states have been tightening their eligibility requirements since the last recession faded out, you may want to think about undoing that, at least temporarily, within the confines of federal law, within what you're allowed to do. And so this letter explained to states how they could do those things and how they could loosen up those requirements. Then on March 18th, the Congress passed the Families First Coronavirus Response Act, or the FFCRA, which provided for a further relaxation of some of those things that we talked about back on the slide, right back over here. So they expanded and relaxed the eligibility for good cause. So the normal rules for good cause, Congress said, states, you can relax that. You can be a little bit more flexible. You can be a lot more flexible with that. Also, able and available to work. You can be a lot more flexible with that. Work search requirements, and then also employer charge. So essentially, it allowed states, the FFCRA allowed states to start giving unemployment benefits to people who wouldn't normally be qualified under able and available grounds or good cause grounds. And this allowed the states to go to employers and say, we're not going to ding you for this. You're not going to have an increase in your tax rates for anything that is COVID related. That's what this legislation did. Finally, about a week and a half after the FFCRA, we got the CARES Act. And the CARES Act provided for more expanded unemployment in the form of a few new programs, completely different programs, which include Pandemic Unemployment Assistance, or PUA, the PUC, which is the supplement, the $600 a week supplement that was in place up until a few weeks ago, and then PEUC, which is an emergency extension of unemployment, 13-week extension. So what happened in Iowa was the day that the FFCRA was passed, on March 18th, 2020, Iowa announced that they were going to be expanding unemployment benefits for COVID-related situations, for people who weren't able to work because of COVID, even if they wouldn't normally be qualified under regular criteria. They also suspended fact-finding interviews. They suspended employer charge and suspended job search requirements. Right now, the only two things that remain suspended for regular unemployment are employer charge, if it's COVID-related, and job search. If it's not COVID-related, which at this point they're trying to shift everybody COVID-related out of regular state unemployment, then it would be employer charge still applies. Job search requirement, though, currently doesn't. I heard just today that Louisiana actually has reinstated their job search requirement, so that's really going to be a mess when we decide to do that. But I don't know when or if that would happen, or when it would happen, and if it would be anytime soon. I worry about it, though. So all of these changes that I'm talking about did not happen through the rulemaking process that I talked about, where they say, this is what we think the rules should be, and this is, we're going to give the public a chance to comment, say if this is good or bad, or if it should be different. All of that process, none of that happened. All of this essentially was just stuff that appeared on their website and in some informal materials that they put out to their website. Luckily, there are archiving sites on the internet, so we've been able to sort of piece together the rapidly changing policy that then ensued over the last few months. This becomes relevant because a lot of people signed up for benefits at the beginning of all of this and were receiving benefits from back in March and are now having to go back and sort of relitigate what happened back at that particular time based on the rules that workforce has decided apply now. And so tracing back that history is important to be able to make sure that people don't get, treated differently than the rules that applied at the time that they applied for benefits. So again, it gets quite confusing, but here's a couple of graphics from back in March, at the very beginning of all of this, that talk about the situations that would allow someone to receive regular state unemployment benefits. So we're not even talking about CARES Act In fact, this one here was actually, this graphic was put together on the 18th of March, which is a number of days before the CARES Act had even passed, and explains all of the situations where someone would be eligible for regular state unemployment benefits. So let's just go through a couple here. Worker is mildly ill with COVID-19. Yep, eligible. Severely ill. Yes. Mildly or severely, doesn't matter. Worker was exposed in quarantine, business remains open. Yes. Caring for family member, at that particular point in time, they were doing it case by case. Schools closed, workers have no child care, eligible. Schools closed, worker is impacted. I think that's for educational workers. Eligible. Advise to self-quarantine, eligible, et cetera, et cetera, et cetera. Now, one thing that is different, I'm going to show you a slightly different graphic that came out 2 weeks later. If you look here at the bottom, it says that all PTO, sick leave, paid sick leave, disability must be exhausted before receiving unemployment. About 2 weeks later, there was a graphic that had almost everything the same, except for that was taken out. Their policy on paid leave has not been, like many other policies, has just been very wishy-washy and kind of all over the place. I wouldn't say wishy-washy, but certainly unclear and all over the place over the last few months. I think there was a question I know that was posed that I might as well just get to now. It was posed in advance that talks about whether or not people have to take paid sick leave before they are able to claim UI benefits. And I think the answer, well, I think it was paid leave was the question. So just any category of paid leave. I think the answer depends on the situation and whether or not the paid leave would be appropriately used under those circumstances. So let's say somebody was diagnosed with COVID. Under those circumstances, if they had paid sick leave, that their company policies would basically say would be available for that kind of situation, that they would have to exhaust that before being eligible for unemployment for the reason of having COVID, being diagnosed with COVID. However, they could not be required to say take vacation leave if that was not a company policy. So it really just depends on how the particular policy, paid leave policies interact with the reason, right? So if you don't have childcare because the schools are closed and you're not able to come to work, you can't be made to take paid sick leave for that. So it can't, it has to sort of be used rationally for a situation when it would be used in normal times. So again, try to get a straight answer out of a lawyer and they tell you it depends. It does depend though. And it's important to think about how these facts matter, and it's important to think about how they fall in these situations. So this is how I think we would look at that kind of case. So, but it's interesting to see how even over time their own policies sort of change, and it's really only by just collecting all this material and trying to piece together a timeline that we're able to really understand and argue these cases where normally we would just be pointing to rules that were created in a democratic way, quasi-democratic way. So anyway, challenging time to be a lawyer and an advocate in this field. Okay, let's talk a little bit about some of the additional types of unemployment by the CARES Act. First of all, we have the first two, which are a little less complicated, and the third, which is the pandemic unemployment assistance. By the way, these are 3 of several programs that the CARES Act created. There are other things that we probably won't be able to get to because we've got a lot of material to get to today. But these are the 3 most important. If you have questions about some of the others, I'll try to answer them if you have specific issues there. But the main types of alternative unemployment or additional unemployment programs are created with the PUC, which I mentioned was the $600 a week supplement. The whole idea behind PUC, remember I was saying unemployment in normal times is meant to be sort of a fraction of someone's wages, so it's not to disincentivize people from going out to work, to find new work. However, right now we have public health concerns that make the idea of going out and pounding the pavement looking for a new job something that puts all of us in danger. So we don't want people doing that. So the idea behind the $600 per week was because you wanted to get close to, and in some cases a little above, but in some cases a little below, but close to 100% wage parity for people, so that they weren't suffering, unable to go out and find a new job, and then not having enough to actually pay the rent and keep the lights on. This payment was not considered to be income for Medicaid or Hawkeye purposes, or HUD or Section 8 purposes. Later on, there was some interpretation that said that. And it's retroactive back to March 27th, and unfortunately ended on July 31st, 2020. We're already seeing at Iowa Legal Aid a massive spike in eviction intakes right now, unfortunately, related to the loss of 600. I'm going to stop 1 second to check the chat here. Okay, I'm going to finish this slide and then I get to this chat. Okay, so pandemic emergency unemployment compensation. In fact, I'm going to get to it here after the next couple slides. I will answer the question though. If I forget, please let me know, but I hope I won't forget. It's been a long day though. I've been up since 5, working on stuff since 5, so it's been a long day. So pandemic emergency unemployment compensation. What this is it's a pandemic-related extension to regular unemployment benefits. So those state benefits that we've been talking about, not PUA, which we'll talk about in a moment. It's a 13-week extension to the current 26-week benefit period. It does have an active work search requirement that allows states to be flexible. You know, Iowa currently does not require work search for PEUC, and they are actually, we have people who are receiving PEUC right now in the state. Okay. So, okay, I kind of talked about this already. The goal is to provide something close to 100% wage replacement. People can receive partial claims for partial reductions in hours. So you don't have to be fully laid off or fully separated in order to receive benefits. Prior overpayment collections, right now they've actually suspended the program that offset people's tax refunds. Unfortunately, some people got dinged early in the year, and most of them didn't even know they were on the chopping block because of the, frankly, I think, what's the word I'm looking for here? Substandard way in which the process was carried out. I think there was a lot of notice issues and people didn't really understand that this was a possibility. Anyway, but starting in March, some people didn't, they stopped the process kind of halfway through the tax refund season, and so some people didn't get their taxes dinged for that. We have had some fraud overpayment issues where people essentially are locked out of the unemployment system because Workforce has deemed a prior claim to be fraudulent or due to misrepresentation. I have a lot of concern about these types of labeling of different, sometimes legitimate claims. There are cases we've seen where there has been, you know, relatively clear misrepresentation, but then there's other cases that we've looked at where it's been really hard to tell how Workforce came to the conclusion that a particular overpayment was due to some kind of fraud or misrepresentation by the claimant, as opposed to misunderstanding or just, you know, a claim working its way through the system normally. So, you know, many other states, Michigan, for example, is a really good example, have had situations where the terminology of fraud has been really grossly overapplied, because if you call a benefit fraud, then you can lock someone out of the benefit system until they pay you back dollar for dollar out of their own pocket. You can assess a penalty against them that is an additional amount owed to the state. You can go after their tax refunds. You can do all kinds of things to them. So I'm really, really concerned about this. So we'll talk about fraud lockouts in a minute, because at the beginning of all this, we were advising people, and people were being told by the Workforce that if they had a fraud overpayment, they were out of luck, nothing. They were getting nothing, even if they were otherwise eligible. So, and then we'll talk about waivers here in just a minute. I think, though, going back to the partial claims, the question that I got in the chat box just a moment ago was about partial claims. And so I'm going to go read that one, and then we got a second question as well. So I'm going to get to these questions now. So the question I have says, an employer had to slightly reduce store hours, open an hour later, i.e. open an hour later, close an hour earlier. This resulted in a slight reduction in people's hours. The employer claimed with this small reduction of hours, employees would not be eligible for COVID-19 partial unemployment benefits. How much truth is there to that? I think that the question here is not necessarily whether it's COVID-19 related benefits, but just unemployment benefits in general, under, again, the sort of partial claim work sharing. And I think it will depend on the sort of percentage of their time and wages that ultimately resulted. And I don't have that formula memorized, But one of the things that I would like to do is to have this group chat saved if that's possible, and then I can come back with some more specific information, send it out to the entire group with some regulatory sites, just so that we can get the exact information. But I think the idea of the COVID-19 benefits, might be a little bit of a red herring there. I think that it really comes down to whether or not they trigger sort of the work sharing regs or work sharing regs. Okay, so Valerie Cohen asks, I'm a steward for school district employed bus drivers. From March through May's end, we got 30 hours per week compensation. However, we typically have 40 to 55 hours a week this time of year. We were told we could apply after May. However, since then, only 50% of claimants have been allowed to receive UI. I'm also hearing that there is a PUC app separate from UI. Is there an advocacy system to help the many varied issues? You know what, I picked this up too soon, because I'm about to talk about PUA, which I think is going to address some of these issues. And I don't have anything about educational employers in the slides, but I'm happy to talk about it because it's an issue that's come up in some of our cases. Okay, so pandemic unemployment assistance, PUA. PUA is essentially unemployment for people who don't qualify for unemployment. So you have to be partially and fully unemployed, and either one, able and available, or two, subject to separation from whatever you were doing to earn money for a COVID-19 related qualifying reason. So this covers people who are not normally in the unemployment system. So self-employed people. This was how this was built, right? This was, we're going to provide for the people, the self-employed people, the gig workers, the independent contractors. But it actually covers a lot more than that. One thing I don't have here, but I will mention, is certain nonprofits that are not normally covered. I remember the first time I ever had a case at Legal Aid where we had someone was working for the Salvation Army, and they had a great unemployment claim. And then my boss told me, no, if you work for the Salvation Army, you don't qualify for unemployment. I was like, that's ridiculous. That can't be right. It's actually true. And so it's always bothered me. But this covers some of those folks who would not otherwise be eligible because of the fact that their employer was a certified nonprofit. People who didn't have enough work credits. So normally, one of the other things you have to do to qualify for unemployment is you have to earn a certain amount of money over what's called your base period, which is a certain number of quarters prior to your claim. A lot of people who didn't have enough work credits during that time, during those times, would normally not qualify for unemployment even if they had worked. However, people who don't have enough work credits qualify for PUA. Fraud lockouts. So I talked about people who were locked out of the system because of fraud. Normally, until 2018 in Iowa, if you had a fraud overpayment, what happened to you was, if you had a new unemployment claim, you would begin to be paid, but then the state would take all that money and put it into, against your debt, which wasn't great in the immediate term, but at least went to pay off your debt. However, in 2018, the state changed the law, Iowa changed the law to basically say, no, now you're simply not eligible for benefits, which means that you don't get to even pay off your old debt by, against the new benefits you're receiving. You just can't do it unless you pay us money out of your pocket. So that is the way the law changed. Interestingly, for the state, if they hadn't changed the law, people who had fraud overpayments would actually just still get that 100% offset, and they would not be receiving benefits in their pocket. However, because of the way the federal statute is written, people who are not eligible for unemployment because of a fraud lockout are eligible for PUA. We've actually filed one of these with the state. We have a client who's a veteran. The underlying fraud claim is pretty weak as well, on top of everything. So we actually approached Workforce and said, hey, we pulled some federal guidance from one of those unemployment letters that I talked about, which are great resources. You find all kinds of great stuff in there. That says that anybody who's subject to a fraud lockout is eligible for PUA, to which they said, you are right, but our computer won't let us pay that right now. So we can either put your guy into the system for an interminable period of time, and we can just let his life completely fall apart while he waits for benefits, or you can agree to just have him sign this promissory note where he agrees that the money gets offset when we make his first payment. They have no actual legal method to do that, but we'll go ahead and expedite it. And, you know, at this particular point in time, our client who needs the money decided to opt for that, even though, you know, there's no legal provision for that. So yes, fraud lockouts, you can get PUA for that, but it will be difficult, and, you know, probably the claim will be shoved into some backwater, processing backwater, unless you really raise process. I was going to say something other than process. So other things, what is really coming to the fore now is people who don't qualify for unemployment because they don't meet one of those basic requirements we talked about earlier. They quit for a reason that was other than good cause. They're not able and available. These are the sorts of things that now are the majority of these PUA claims. And some people are actually being pulled out of PUA, being pulled out of their state unemployment claims and pushed towards PUA for these reasons. We're going to talk about that very specifically because it's a very big problem that a lot of people are facing right now. But to get to the question, I'm going to read the question again just for everybody's benefit here. So this is the steward for the school district employed bus drivers. From March through May's end, we got 30 hours a week compensation. However, we typically have 40 to 55 hours per week this time of year. We were told we could apply after May. However, since then, only 50% of claimants have been allowed to receive UI. I'm also hearing there was a PUC app separate from UI. Is there an advocacy system to help these many varied issues? So I think probably what we're talking about here is a PUA app, not a PUC app. Remember, PUC is that $600, there's too many letters, what do they call it, alphabet soup? It's a real alphabet soup situation here. We like to create acronyms. I mean, the government does, I guess. So in any event, PUA is what we're talking about here. That's that alternative unemployment. And one of the issues that people who work for educational employers have been running into is the general, so there's a very specific eligibility requirement for people who work for educational institutions where people have semesters and spring break and summer break and things like that. This is federally imposed. It's not something the state came up with. Basically, if you had to boil it down to its basic idea, you can't receive unemployment for something for a period of time when you essentially wouldn't be employed because of a break in the school year. Unless you were able to show that there was no reasonable certainty that you would have your contract renewed or otherwise be brought back for employment when the school year resumed. That is essentially copied over into our state code. So under these circumstances, I think that you know, one of the issues that people are probably running into is whether or not they're qualified for regular unemployment or PUA. I think under these circumstances, there's at least a PUA claim here for that additional amount. PUA goes back and it calculates the benefit amount based on the highest earning quarter within the base period. So if you have a higher earning quarter within the base period, you would be able to show that you would be able to generate your benefits from that. And also, I think the reduction in hours, from one semester to the next would, I think, create a PUA claim in that it would be a partial claim. This would be my argument. I'm thinking this through as I'm talking about it. It would be a partial claim because essentially you would be making a claim as an educational institution worker and you did not have a reasonable assurance that you would be earning the same amount of money. Your proof is that you're not at this particular point in time. And so that actually might be a good state unemployment benefits claim, partial claim. I would actually try both. And to get to the second part of your question about the PUC claim, the PUC, PUA app is what we're talking about, not PUC. There is a separate PUA form. But again, as I think about this, I think this might just be a regular state claim. This might just be a regular state claim because it's really just about, ultimately, you're an educational institution worker and you have not been given a reasonable assurance of the same, basically that you're going to be brought back under the same terms. and the proof is that you're not getting paid. I guess that's my initial take on it. If I think differently, when I get the chat log here, I might add more information later. Okay, got another two questions here. Reappear says, I'm a business rep for industrial carpenters. The plant shut down for 2 days to disinfect due to a positive COVID case. The members filed for unemployment. Some received it, some did not. Those who did not earned $10 to $20 more than they could be to be eligible. So we had members working side by side. Some got unemployment for 2 days, plus the 600, while others got nothing. Is there anything to help them? Can they apply for PUA? Members filed for unemployment. Some received it, some did not. Those who did not earned 10 to 20 more than they could to be eligible. I'm not sure I understand actually what that's saying. So what you're saying is that they were told that they earned too much money to get unemployment. I'm not sure that I understand exactly what the issue is there. If you have any more information, that might be helpful to add. Correct, but only by a small amount. Yeah, there's something about that doesn't sound right to me. I mean, there's generally not an upper limit wage-wise for receiving unemployment. Partial unemployment claim. That's possible. So Robin had mentioned, I think that's right, actually. Robin had mentioned to me privately, thank you very much for doing that nicely, but I'm going to go ahead and out myself here. There is a partial unemployment based on earning no more than $15 over your weekly benefit. So that's probably it. Thank you, Robin. That's a good point. So then, let's see here. Valerie then mentioned, again, going back to the school bus question, typically we do have enough summer work for all who want it to work about 20 hours per week. But this summer we got the opportunity to work 0 to 8 hours per week for baseball, unmasked, unsafe shuttles. Sounds like a really great opportunity. And I'm being sarcastic, as I think you are. Okay. Got one more chat here. I'm glad you guys are asking lots of questions. Similar to the furlough question I asked, employees were reduced 20%, but still made too much to qualify for UI. Right, because it has to do with whether or not you have that $15 more over your weekly benefit. Thanks again, Robin. Okay, pandemic unemployment assistance, a couple more things. 39 weeks are available in total until December 31st, 2020. People who receive pandemic unemployment assistance are not eligible for either of the main extended benefits programs, either PEUC or the general extended benefits program, which we'll talk about in a minute. PUA is retroactive to February 20th if the separation was COVID related. For self-employed people, there is a form where you have to supply income and some other answers to other questions as well to determine whether or not you were separated for COVID related reasons and other things like that. There are specific reasons that people can receive PUA. First, they have to have been diagnosed with COVID or seeking diagnosis. Two, they have to be diagnosed with COVID-19. A household member, rather, has to be diagnosed with COVID-19. Notice the difference there. Self-diagnosed or seeking diagnosis, household member diagnosed. Providing care for someone diagnosed with COVID-19 or providing care for a child or other household member who can't attend school or work because it is closed due to COVID-19. They're quarantined or have been advised by a healthcare provider to self-quarantine, the latter being much more common than the former. They were scheduled to start employment and don't have a job or can't reach their place of employment as a result of a COVID-19 outbreak. This one is particularly sad. They've become the breadwinner for a household because the head of household has died as a direct result of COVID-19. So if someone was, let's say you had a family where only one person was really earning, then if that person dies, the widow or widower could receive PUA if they were able to demonstrate that. They had to quit their job as a result of COVID-19. Their place of employment is closed as a result of COVID-19, or they meet other criteria established by the Secretary of Labor, who has not established any other criteria at this particular point in time. Other sorts of expansions. So, you know, for the most part, people who receive, say, PUA don't necessarily need to have had a COVID-related separation. In other words, they don't have to have been laid off from their job because of COVID. They just have to be unable to work because of COVID. So let's say you had someone whose job ended back in January, and they quit their job for a reason that was not good cause, and they wouldn't otherwise be eligible for unemployment. But now they can't work because of COVID. Maybe they have to self-quarantine, maybe they don't have childcare. Under those circumstances, they could apply for PUA, even if they weren't literally separated from employment because of COVID. It's a slight distinction, but important. Telework availability. A lot of these claims, the ability to do telework is going to be a really important fact in a hearing. If reasonable telework is offered and the claimant refuses to do it for whatever reason, then that is going to be disqualifying. However, if it's not reasonable, telework, you know, let's say the person normally works 8 to 5 and, you know, has kids at home, and you're like, you know, you need to be, I don't know, talking with people in Australia from 1 in the morning until 9 in the morning every day, that may or may not be reasonable, telework. If the schedule differs or the nature of work differs, those can be facts that go to whether or not telework is reasonable. But this is going to be a major fact in certain cases. So paid leave must be exhausted before UI can be claimed. To the extent that we talked about the limitations of that earlier, I think the way we discussed it earlier is a more accurate description of the rule. Okay, talk a little bit of extended benefits. Extended benefits are different than the pandemic emergency unemployment compensation, but are also a 13-week extension. They actually stack on top of the pandemic emergency unemployment compensation, possibly for a total combined benefit period of 52 weeks maximum. It won't always end up being that much, but it's a maximum of 52 weeks. The extended benefits program comes after everything else has been exhausted, and there is a work search requirement unless there's a waiver in place, as there is now. You also have to have had total wages in the last 4-quarter base period equal to or greater than 1.5 times your highest quarter wages. So there's a wage requirement as well. So who is eligible for extended benefits? People who are receiving traditional UI, people who are getting PEUC, and then a few other you know, more niche types of benefit programs like Trade Readjustment Act. Employers left the country to relocate somewhere else. People who are left behind get TRA benefits, business closing benefits, and training extension benefits. So who's not eligible? Well, self-employed people, independent contractors, and gig workers, and any PUA recipients. So one of the things that's happening now is there's this shift to get people off of regular unemployment over to PUA. One of the big consequences of this is you are now going to be giving people a shorter benefits period, maximum benefits period, because remember, PUA, 39 weeks max, and then at the end of the year, unless Congress does something, it's done, even if you didn't get your full 39. On the other hand, if you're getting regular benefits, then the PEUC and the extended benefits, you have a kind of open-ended 52-week maximum. So there is a difference which road you go down. And so that is something that you have to weigh as you sort of determine whether or not you're going to take the PUA path or fight the regular benefits path, as many people, a choice many people are finding themselves facing at the moment. What do those executive orders mean? At this point, in my opinion, nothing yet. That's all I'm going to say about that. Okay, let's talk a little bit about practice. I'm going to talk just a little bit about some of the mechanics of doing a case, just basic kind of appeal structure, some thoughts about what's called discovery, which is asking the other side for documents and asking them to answer questions, things like that. Then I'm going to go back into the whole PUA regular unemployment choice once we sort of talk a little bit about hearings and the way those go. So first of all, before we even get to the hearing, let's say you're helping someone, or you know, in most cases helping someone else pursue a claim, and you need to get information from workforce development. A daunting task sometimes. When we first went into all of this, they have been slowly over time making it harder and harder and harder for third parties to get information on behalf of people who are trying to help, even attorneys. Not like we should be any different than anybody else, but you know what I'm saying. So at the beginning of the pandemic, their position was that in order to give information to someone who was helping a claimant, you had to have the claimant execute a notarized power of attorney, which is frankly ridiculous and not required by the law. So when we started getting them basically refusing all of our information requests unless we gave them this document that was not only a barrier to get, but also, you know, you're forcing someone to go out and get something notarized, which means face-to-face contact with somebody. Right now, when it's not necessary, it was sort of maddening. So we pushed back on that, and they relented temporarily because, you know, and their position is, well, we want to protect the confidentiality of information. I just don't buy it myself. I think it's there as a barrier. So anyway, there is a form that they have now, a simplified form that they have now given to us to allow us to get information without having to jump through that hoop, which I will have to make sure that I send, because you guys might not have that and you might find it useful. But if you get pushback from using this form, which you might, because they sent it to us mainly because we complained, what I would point out, and I should also send this email along too, I sent an email basically breaking down the code and explaining why this was not necessary. And so I'm happy to give you also the argument as well as the form. So write that down so I don't forget. Okay. So let's talk a little bit about the appeal structure. There's several levels of appeal structure for these things. And confusingly, sometimes appeals can be, different issues can be happening at the same time. So you can have different issues on appeal at different stages. It is confusing. Going through and untangling the kind of appellate process in these cases is really one of my least favorite things to do, because a lot of times, yeah, it's very confusing. So, fact-finding hearings. If a case is challenged by an employer, usually, the first step of sort of dispute resolution or investigation and determination of the claim is what's called a fact-finding hearing. This is very informal. Under normal times, what happens is the department sends out a notice telling you when there's going to be a kind of informal telephone interview. Claimant gives information, employer gives information. Sometimes it's the same call, sometimes not. And then ultimately, at the end of the day, the fact finder makes a decision. Fact finders are not legally trained, usually, if ever. And again, it's sort of this frontline decision. Right now, they're happening differently than normal in a way that's actually very concerning to me, but something that people should know about, especially if you're helping people with these claims. So they're doing something called cold calling now, where if you have a fact-finding interview, instead of telling you that you have a particular time that you have to be available, they're just calling you. And if you don't respond within 48 hours, they just go on without you. And generally speaking, that's not going to be good for the claimant. So it's really important for people to be watching their phone. And also, even if you think your claim is set and you've already fought it out, or you've already been approved, they're also kicking people off of benefits, again, for reasons that are very hard to predict. So unfortunately, right now, people have to be vigilant, and if they get a call from workforce, they've got to figure out what they're going to do relatively quickly and make sure they get back to people. We've heard a lot of really bad stories about how this has gone as well, especially with people who are not native English speakers. We've had several reports, multiple reports of people who are Spanish speakers that have called back, and when they try to request an interpreter, they just get hung up on. So that is a problem, and something that I think, normally a lot of people don't necessarily have advocates at the fact-finding level, and in fact, the fact-finders won't even let you talk very much as an attorney. You might be able to talk a little bit at the end of the process as an attorney or an advocate, but under these circumstances and the way things are happening now, I think it could be really helpful. Got two chats that I just want to take a quick look at. I got one that's just if you can, please share your PowerPoint presentation. Yeah, that's going to go out to everybody. So I will send that along as well. Everybody, if you find it useful, hopefully you do, that's available. I had another one. I have one where they claimed they called and never left a message, and the caller ID said nothing about IWD. I heard that one too. And so the cold calling makes it really easy for them to say, yes, we did it. We gave a call, but it's impossible to verify because there's no time, there's no hearing. There's some really, I think, troubling due process issues in a cold calling hearing system. So we're actually looking at whether or not there's a systemic way to challenge the practice. Their perspective is, we have so many of these to do, this is the only way we can get it all done. I don't know. Robin mentioned, by the way, in response to the PowerPoint question, said that we're recording this, so we'll send the link out to all registered Apple participants. If we don't get through it all too, there's some stuff about overpayments at the end too that we're probably not going to get to that might be interesting to people. So there might be more in the slides than there is in the recording. Okay, so then after the fact-finding hearing, either party can challenge and take it up to the next level, which is an administrative law judge, Iowa Workforce Development. Right now, actually, they're pulling in administrative law judges from other agencies in the state. Department of Inspections and Appeals ALJs are there. Other workforce ALJs, like the work comp folks, are being pulled in to do unemployment hearings. People who aren't normally doing these cases, which, I don't know, is not necessarily working out too badly. There's a lot of former legal aid attorneys there who've done a lot of unemployment, which, frankly, I think is a good thing. So the mix of judges now might not necessarily be the worst thing in the world with the extra folks. The ALJ hearing is important because it's really your last chance to get in evidence. So once you go beyond the ALJ hearing, even if you come up with like the best evidence ever, and it's really solid for your claim, and it really just brings the points home you want to make, it's probably too late. It's probably too late, which is why these ALJ hearings are super important, critical. You got to get the evidence in then, because after that, you have levels of appeal. The only thing you can say after this is, judge below got it wrong, based on what was submitted at that hearing. So this is your last chance. This is why these are the most important. Fact-finding hearings, not super important. They can save some time, but you can hear what the other side has to say. Good investigative process. The ALJ hearing, that is actually where things are serious. So you have 10 days to appeal to the ALJ. You have to get your evidence in then. An ALJ hearing is going to be something like a hearing in court, sort of at the courthouse. Rules of evidence kind of, although kind of relaxed. So the rules of evidence kind of apply. The structure of things where you have people testifying, and someone, if you have an advocate, they can ask you questions and they can cross-examine the other side. Those sorts of procedures kind of apply. ALJs tend to ask a lot of questions on their own, a lot more than a judge would in court. And in fact, that's one of the things that makes these sort of tricky to prepare for, because you don't know, you can prepare a bunch of questions and prepare how your story's going to go, but really the judge is going to start asking questions right out of the gate. And so since you don't know what the judge is going to ask, it's hard to prepare what you're going to say. What I always do when I prepare for any kind of trial is I never write out questions. I always just write out facts that I want to be in the record. What are the things I need to be in the record? What are the facts I need the judge to agree with to win this case? And so I write those all out. And then if the judge asks a question and the fact comes out, I just cross that one off of my list. And if it comes out wrong, then I figure out how I'm going to flip it. Because you do get a chance to ask the questions later, or the claimant does get a chance to tell the story their own way after the ALJ is finished. But the ALJ is going to go first, which can kind of throw you off if you get rigidly focused on specific questions you're going to ask. So don't do that. It won't work. Once you have the ALJ hearing that doesn't come out your way, then you have 15 days to appeal to the Employment Appeals Board. Employment Appeals Board is another administrative agency. It's got 3 appointees, one who's an employer, one who's an employee, sort of representative, one's an employer representative, and one who's neither. I'm not sure what that third person really is. I've never really understood that. Anyway, but that's the way the law is, and that's what it requires. Employment Appeals Board, you're just going to be making arguments. You're not going to be talking to anyone in person. You're going to be writing down your arguments. A lot of times, when we do these, we write them as a legal brief and just say, judge below got it wrong. Or if we're on defense, the judge below got it right for these reasons. And we point to the evidence that was pointed to that we submitted in the ALJ hearing. That's the way these go. They vote, and normally, almost always unanimous. Sometimes you get a dissent. And then at that point, that decision becomes final. Then you have, if you don't want, like the way that one went, you have 30 days to appeal to an actual district court. You can either appeal to the district court in Polk County or the county where someone, the claimant lives. There is actually no fee to file these. You can file the judicial review case in district court for free. Normally there's a filing fee, but these cases do not have a filing fee. However, again, you're going to be arguing that this time, not only did the ALJ get it wrong, but the EAB got it wrong. That depends on whether or not the EAB reversed, actually. Anyway, not always. It's not always going to be that particular setup. But the main thing is it's going to get more and more abstract and kind of legal, based on legal argument, the further up the appeal chain you go, which is why it's so important to really get in and do a good job and get everything in that you can at the ALJ hearing. That's the most important part of the chain. Okay. Okay, discovery in UI cases. We talked about the ALJ hearing, getting that evidence and how important it is. So what is discovery? Discovery is just a lawyer word for getting information from the other side. And there's a few different ways that you can do that. You can ask for what are called a request for production of documents. And I can actually send some samples of those. Request for production of documents is a request for production of documents. It is what it sounds like, in other words. So basically, you are asking for documents the other side has. You want to get them before the hearing so that you're able to review them, both to figure out what the other side is going to put in and to sort of investigate the case, and also to get any exhibits you want to make sure you get in for your person. Another thing that you can send the other side is something called interrogatories, which is just a really unnecessarily complicated way of saying questions. You can send these questions to them and they have to answer them under oath. You can use those questions to, again, get information about a claim. You can use them to prevent someone from basically being able to answer on the fly. If you want to box someone in to a particular answer before, so you know what they're going to say about something, you can do that. If you want to resolve an uncertainty, there's lots of reasons to do it. The downside to really asking a ton of questions and asking for a ton of stuff, specific stuff, is that you give the other side a sense of what your argument's going to be. So there's kind of a give and take there, just sort of as a method of, as part of the art of advocating. If you ask too much, you give too much away of what you are thinking. So it's a trade-off. It depends on the case which one is a better tact.
And just to provide a little context for this quickly, this is amazing, by the way, Alex. Thank you so much. This is a wonderful workshop. Some of you will know this on the call, that that workers can represent themselves in that ALJ hearing. They can have an attorney represent them, or they can have a non-attorney advocate. And because of, legal aid has been absolutely swamped, and not everyone, has the ability to hire a private attorney. And so that increasingly we've heard from a lot of community groups that are finding themselves in this position of advocating, particularly where there's an overpayment that the department is alleging, that the agency is alleging. So so some of you have found yourselves in this position. And for others who haven't, that could be a possibility.
And there's a really good question here from Mayra Hernandez, who says, when you say write out facts, how do you then frame them into questions if you're looking for a specific answer? But the judge says you must ask an open-ended question when it is your turn to speak as an advocate during hearing. Okay, so what this is that this is talking about the problem with leading questions. So you're only allowed to ask leading questions of the other side. So if you're talking to your own person, then you have to ask them open-ended questions. As far as figuring out what the answers to those are, that's basically witness preparation. And I do not mean telling the witness what to say, because don't do that. People should tell the truth, and it's important to tell the truth, and you have to think about and create your argument based on the truth. But you can sort of say, go through them, different questions with them to sort of get a sense of how they might answer them. Now, of course, that's going to be difficult, as I said, because the ALJ is going to have a chance to ask them. So these cases, these sorts of hearings do really require you to think on your feet a little bit, which is why I think having those facts down there as a way of being able to, it's easier to, I think, adapt to, the uncertainty of what the ALJ will or won't ask. So just having them down there, but you have to ask them in an open-ended way. Let's say you were asking a question and you wanted to get at the fact of, when an employee gave a healthcare provider certification that they needed to self-quarantine due to high-risk factors related to COVID. You would ask questions like, did you consult with a healthcare provider? Who did you consult with? When did you consult with that person? Did you get a certification? What did the certification say? Did you provide a copy of that certification? Did you bring one with you, or did you provide it to the ALJ? And then, you would say, Your Honor, we have this certification we'd like to admit into evidence. So those are the sorts of things that you might ask on direct. Let's say you were cross-examining someone, the other side. In that case, you can be a little bit more suggesting the facts. In fact, the classic form of a cross-examination question is to say the thing and then to say, isn't that true? You received this certification from her on May 19th, isn't that true? And then once you received it, you blah, 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 blah. Isn't that true? So that's the difference between a leading question and an open-ended question. You can't ask leading questions from the people that are on your side. You can ask them against the other side, and should ask them against the other side in most cases. Talk a little bit about, I'm going to finish discovery, then we'll talk a little bit about exhibits, because I think that's important. And I'm not sure I have a slide on this, but actually it's super critical. And I'm glad that it came up. So discovery in these cases, so you send them your interrogatories, you send them your request for production of documents once you decided what you want. Then what happens next? So once you send it to them, they have 10 days to answer. They have 10 days to answer unless they apply to the ALJ and get an extension. That seems like not a very long period of time, but let's say they don't answer in 10 days. They just don't send you the stuff. They just don't do what they're supposed to do. Then what happens? Well, then you have to go to the ALJ and say, hey, I sent this. They never sent a response. What do I do now? So then the ALJ will have to look at the situation and say, am I going to force this person to answer these questions? Then the other side can say, I don't think I should have to answer these questions because of reason. And then the ALJ has to decide whether or not they're going to actually make them answer, and that's going to take time. And then once that all works out, eventually, if the ALJ tells them, you must answer these questions, you must provide these documents, and they don't do it, then at that point, you can ask for what are called sanctions, which means some kind of punishment for the other side, which usually means they're not able to bring evidence or say certain things. They're just barred from saying certain things and putting in the record. And in some cases, it might even be a dismissal of their challenge. You can ask for lots of things as sanctions. That takes time to play out. In the meantime, they're trying to push as many of these hearings through as quickly as possible. So if you're going to ask for discovery, think carefully about what you want, but think quickly. Because if you don't get it in time, then that process is not going to have a chance to play out, and you're going to have the hearing before you can actually figure out whether or not you can force them to answer the questions. So if you're going to do discovery, and I think it's a good idea in a lot of cases, do it at the very beginning as quickly as you can. Unfortunately, the time frames are not forgiving. Okay. Okay, I'm going to talk about this, and I'm going to talk about exhibits. So other methods of getting information besides discovery. One, you have a right to a personnel file under Iowa Code Chapter 91B, subject to just a few kind of basic restrictions. They have to provide, they can ask for reasonable copy fees. They can set reasonable restrictions on if you're going to just go in and review the file, to say the hours, who's going to be there, et cetera. But they have to be reasonable restrictions, and the fees have to be reasonable. And that's true outside. You can ask for the personnel file outside of the context of unemployment. It doesn't have to be an unemployment dispute. Okay, where IWD is a party, say overpayment cases, you can ask for discovery against Iowa Workforce Development. You can also ask for what's called an open records request, which is like a FOIA or a federal Freedom of Information Act request. Basically, they have a responsibility as a public agency to give you certain information as long as it's not protected under law. You can also, if you need to get someone who's not the employer or the employee to testify or produce documents, you can ask for what's called an administrative subpoena. You have to ask the ALJ for that. Let's say you need to get, like, I don't know, video from someone that's not either employer or employee. Let's say it's a temp case. You're talking about someone who's working for a temp agency, and you need to get some video from someone who's like a site supervisor or the site themselves. The temp agency is not going to have access to that, so you're going to need a subpoena to get that video, etc. You have to ask 3 days prior to the date, and the subpoena disputes, if there's a dispute about a subpoena and the ALJ rules a particular way, you can actually stop the whole case and go up to district court and get the dispute on the subpoena ruled on, which may or may not be advantageous to you depending on the situation. Finally, you can also ask for the fact-finding file from the fact-finding interview, which sometimes can provide good information. Okay, I've got some chats here I'm going to get to. Let's see. Okay, first, can you give us an example of an open records request? Probably. Pretty simple. I probably can. I'm just trying to think if I can do one that's going to be. Some of ours have a lot of information in them that's not necessarily something I can share. So I will do my best to find something. Does any of this apply to employers who receive PPP? Can you get into PPP tonight? I will try to get there. So I'm going to speak really quickly about, how about this? I'm going to speak really quickly about evidence, and getting in evidence. It shouldn't be too long. Then I'm going to go to the PUA dual tracking issue, and then I will try to end up with suitability of offer of employment in the context of COVID, which touches on, but then is more than PPP. Okay, exhibits, which is not a slide. Basically, super important, really basic. If you're going to be introducing exhibits at an ALJ hearing, you must call in several days in advance to make sure that you know exactly how to get those exhibits to the judge. This is not going to be a situation, you know, they do have in-person hearings sometimes in normal times, but obviously not now ever. So you need to figure out how to get the exhibits to the judge, and you need to figure out how to get the exhibits to the judge several days in advance. Also, when you give the exhibits to the judge, you also need to give the exhibits to the other side. If you don't give the exhibits to the other side, or you don't get them to the judge in time, the judge may just say, sorry, I'm not putting these in the record. And maybe you did a ton of discovery and a ton of investigation, and these exhibits are really critical to building the record. And even if you get an ALJ who's not going to rule your way, you can use them to win an appeal later on. You can't get them in because you didn't figure out in advance how you were going to do that, then you're really out of luck. So it's really important not to, you know, these are the kinds of small mistakes that can make a good case bad. And so you want to make sure that you really, in advance, figure out how to get those exhibits to the judge. A lot of times these days it's email, but you want to just make sure you're 100% know what the procedure is and you're doing it as timely as possible. Very important. Okay, so let's talk about PUA dual tracking. This is what we call the issue of people who were receiving regular unemployment and then at some point were told, you were never eligible for this, and so now you owe thousands of dollars in overpayment, but you may want to try applying for PUA. And I think I'm saying it much more clearly than they do, but that's really what it all boils down to. So this is a huge problem. We're seeing, I would say at this point, even just at Legal Aid, hundreds of these cases. I really, 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 really worry about these cases. I think the idea here is, there are lots of reasons why the state would rather have people on PUA. First of all, PUA is entirely federally funded and doesn't come out of the state's trust fund. So it's sort of a net zero loss except for the cost of administration, which I think is significant, but still are going to be the same no matter what, more or less. And so, that's one reason. Another reason is there's less of a benefit period, as we talked about, maximum 39 weeks, ends at the end of the year, as opposed to regular benefits, which with the 2 extensions can go up to 52 weeks with no date cap. I would say another problem here is that a lot of people, when they're told they were never eligible, just drop out of the system and don't appeal and don't apply for PUA, and then just end up with the overpayment. A lot of people are not really able to sort of look at this and put the pieces together and figure out what they need to do. So basically the story and the way this argument that we're starting to raise right now, it goes something like this. So as we talked about back in March 18th, when the FFCRA was passed, Congress gave the states the power to relax able and available good cause employer charge. They did that here in Iowa. Iowa took them up on that. And we had COVID-19 benefits, which are demonstrated by all the literature that was being put out by Iowa Workforce at that particular time. At some point, Iowa Workforce decided that the eligibility criteria for regular benefits should go back to what it had been before. However, there is no mention anywhere of when this change in policy took place. But it is true, definitely, that at least for the first couple of months, you could receive regular unemployment benefits for these COVID-related reasons. However, people are now being told that they never were eligible, which is simply not the case. So there's been no rulemaking. Normally, in order for a rule like this, a policy change like this to be enforceable to the point where it actually costs people money and ends up with a loss of property, which is what these overpayment debts essentially amount to, there has to be some kind of process to create a rule so that people know what the law is. That did not happen. So right now, though, people are being told you're not eligible, but you can apply for PUA, and you can try to backdate your PUA claim back to the beginning of your prior claim, which sort of works in a way and sort of doesn't. But a few things to talk about before we get there. One of the problems that we're seeing for that on that argument is we've seen people who have had regular unemployment claims dating back to, say, March. Then they apply for PUA, thinking that it's going to cover at least the debt, right? Because you can make it retroactive back to February. However, then they get their PUA claim acceptance or approval letter, and it dates it back to June. So the problem with this is I think some people are not going to understand the debt part of this, and they're going to say, oh, thank God, my benefits are going to continue. I can pay the rent this month. They're not going to think about the fact that now they still have this debt going back to March because the PUA claim start date was set several months and doesn't completely cover. So one of the most important things to think about is that if you have one of these cases, I think it can be a good idea if someone is eligible for PUA to apply for the PUA benefits while keeping your appeal open for the regular UI. Once you get the PUA decision, you can look at that to see, one, does it cover the entire overpayment? And if it doesn't, you can appeal that too. And then you've, of course, got two threads going, which is confusing, but at least preserves people's rights on both paths. And then if ultimately the PUA claim does cover the entire overpayment, then you've got a choice to make. The choice is, do I take these benefits now, get my client or the person I'm working for paid now, knowing that the downside to this is that they're not going to continue after December 31st under the current law, and you're not going to have that 52-week maximum, but you're going to get the money today? Or do you keep fighting going forward on the appeal? Now, if you don't have the PUA claim covering the overpayment, definitely you fight as hard as possible on both until one or the other works out, hopefully. But if the PUA claim does cover the overpayment, I think there's less of an edge on the issue. in those cases. I hope that makes sense. I'm not sure that it does. I mean, it doesn't make sense. It's not, there's no, like, normally, again, there are policy and rules you can look to make some sense out of things. What lawyers try to do. But this is just what, you know, our tactic currently is to deal with what is really kind of a void of rulemaking. And so far, we've been able to help a number of people with this strategy. So it seems to work. Again, but those are your choices once you get down to the road. Anyway. Okay, so then I said, I just talked about this. I have a ton of stuff in these slides that I'm not going to get to. I'm just going to kind of quickly tell you what it is so you can take a look at it. So I have a lot in here that talks about good cause quits. I kind of talk a little bit about separation and what constitutes good cause to quit. I go through all of, there's a set of 2 regulations that talk about good cause quits, and I break those down. There's a ton of things in here, as you can see. There's a list of no good cause quits and then good cause quits. Hopefully these are helpful, but I'm not going to go into them. They're in the slides. Then I have a section about fear of returning to work equaling good cause. This in and of itself could be an entirely separate training, and maybe we should even do that at some point. In fact, maybe next week we can come back and do good cause quits if people think this is useful. If not, that's fine, but happy to do that. I talk about how OSHA and CDC standards can go into good cause and a couple of other things. But I said I would talk about paycheck protection at 7:26. I'm going to run a little over, but I wanted to get to this since I said I would. So, suitable work and pay cuts. We got this question a few, maybe 2 months ago, and it ties into the PPP, but it's slightly different. So, question was, I've been told by my former employer can cut my pay by 25% and call me back to work, and if I refuse, I'll lose my unemployment. Is this true? So we looked into it, and so there is a reg that deals with suitable work. It's called suitable work. And it's a separate disqualifying event for unemployment insurance. So remember, going back to the beginning. I'm not going to do that, so it's taking forever to get back there. But you know, you have to be separated for the qualifying reason. You have to be able to work, available to work, and you have to be searching for work and accept suitable work when it is offered to you. There are certain presumptions as to when work is not suitable. If a position is vacant due directly to a strike, lockout, or other labor dispute, it's not suitable. If the wages, hours, or conditions are substantially less favorable, it's not suitable. And if the position would require or prohibit union membership, it is not suitable. So there are various factors that courts look at when we're calling someone. And the thing is that normally the way that suitable work comes up is it's some other employer that you've never worked for before. Like you've applied, you do your 3 applications a week, and somebody offers you a job, and then the question is the job that you were offered by this other employer suitable compared to what you were doing before? But there is a reg that says that this same reg applies to callbacks from, you know, your former employer who's like your boss. So is it a violation of the worker's health, safety, or morals? Physical fitness of the worker is an important thing to consider. However, it requires documentation. And so if you say, I'm not physically fit to do this job at this point, then you have an able and available problem, and they force you to create a record of your able and available problem with the reg. So in other words, if you say, this job, calling you back is not suitable because I'm no longer physically able to do this, then you got an able and available problem, and you might be disqualified on those things. Your other things that are considered is your prior training, how long you've been unemployed, prospects of securing work in the worker's customary occupation, distance from residence, and then pay. There is a formula for pay, and it depends on how long you've been unemployed. And if you've been unemployed for 1 to 5 weeks, you have to be paid 100% of what you were making before. If it's 6 to 12 weeks, it's 75, 13 to 18, 70, and then more than 19 weeks, it's 65%. You can't take someone below federal minimum wage, but it does apply to former employers by reg specifically. How does this tie into PPP? Well, PPP also, they can take you back and cut your pay up to 25%. If they take you below 25%, see the reg for suitable work allows them to take you to 65. But if they got PPP, they can only take you down to 25. Otherwise, they start getting tax consequences that are going to essentially nullify whatever your pay cut would be at least. So that is how those things play together. Another thing about PPP that I want to mention that really ticked me off when I saw it was there was a a lot of language that said, if your employer gets a PPP loan and you do not return to work, you are committing fraud. That really ticked me off because there are several situations when you might not be able to return to work that are COVID related that would not be fraud. For example, if you didn't have childcare because the school was closed or the daycare was closed and you didn't return to work from an employer, even if they got a PPP loan, you were still eligible for unemployment or PUA. Take your pick. So there was a lot of overbroad kind of scare language that came out that I think, you know, I would definitely push back against. If you had an independent reason for being unable to work that was COVID related, and even if your employer got a PPP loan, unless there was some kind of telework available that you could have done that was reasonable, then you would still be eligible for unemployment in that circumstance. I got a bunch of chats. I just want to check them because I just shot past a bunch of things and I wonder if I have already, let's see.
And I'll just say mine, you're okay to go over time as long as you're able. I realize we may lose some people who scheduled for this, but I think it's terrific to hit on some of these points. And we would love to schedule another class as well.
Yeah, I think we should, and definitely maybe next time we can focus on good cause or anything else people want to focus on. So I got a question from Colin Gordon that says, PUA just pays a minimum benefit, right? PUA claims unlikely to cover repayment of a regular claim. It kind of depends. Actually, on the lower end, PUA pays more at the very lower end. In the higher end, it can pay less. So that is the other issue. I think that's a good point to make, is not only does it cover the time period, but also does it cover the actual amount. So these are things that you want to make sure that you verify and check before you dismiss the appeal on the regular unemployment side of things. Then just offer more trainings, happy to do that. And then if IWD demands repayment of regular state claim plus PUC, is there a mechanism by which they repay the feds the PUC money? That's a really good question. I don't know the answer to that. What I do know is that when it comes to overpayments, if you owe an overpayment of regular unemployment or PUA, you have to pay the state back. It doesn't even matter if it's not your fault, you have the most sympathetic story in the world. However, if you're talking about the PEUC extension or that $600 a week, you can ask for a waiver of the overpayment. You have to show, if you want a waiver, that it wasn't your fault that you got the payment, like it wasn't some intentional thing you did to, spur the payment. And secondly, you have to show that it's against the principles of equity and good conscience. In other words, it would be an injustice to require this person to pay it back. So let's say, for example, that the state kept changing the rules, right? Let's say you're past your time to be able to appeal the state unemployment claim because your time has run out. A lot of people's deadlines have run out. And we can talk about deadlines next time too, and good cause for extended deadlines. Let's add that to the list for the next one. But I'm going to add that to the list for the next one. So let's say your time has passed, but then the issue of whether or not you owe an overpayment now is now the issue. So first they determine, did you get overpaid? Were you eligible? Let's say you didn't appeal in time. That decision now becomes final. So now it's like, do you have to pay the overpayment back? So now the argument becomes, if you have that PUC supplement in particular, at least for that part, which is going to be the majority of what someone owes, is this something that this person should have to pay back? Was it their fault? And is it an injustice that they should have to do this? And again, as I was sort of starting to say, if the state keeps changing the rules on you, it really seems like it's not your fault and it would be an injustice, at least in my opinion. Okay. Richie Kurtenbach asks, I have a question. As case law, for example, UI is ruled on as a list of cases approved, the ones denied. Is there a listing we use to gauge cases on? So when I first started doing unemployment cases, what I would do every time I was getting ready to do a hearing is I would go to Iowa Workforce's website where they have decisions posted. And I would just search my particular issue and read like the last 10 ALJ decisions or last 20 ALJ decisions to see how they actually address these things. And a lot of them are very similar. Like they're almost all kind of cookie cutter, cut and paste paragraphs. but you can start to get a feel for, how they're going to work out. I will say the fact that there are a lot of ALJs who are not doing these, who are not workforce ALJs, might create more variety in the decisions, but still, if you have one of these hearings, I could not recommend that method enough. That's how I started when I didn't know anything. I listened to other attorneys who had done stuff before, who had done these cases before, of course, but just to get a feel, if you search Iowa UI decisions, you'll get to a site pretty easily through Google where you can pull these decisions up and you can search on any number of things. You can also search your own employer to the extent that they've made arguments in the past that might help you know how that employer is going to argue a particular case. To the extent that you can get a lot of facts from them, some of them are don't have a lot of meat as far as facts and fact-specific, case-specific information. So, okay, why don't we go ahead and stop there. I'm glad folks seem to have found this helpful. Lots of good questions. I really like that. I'm going to send these slides, a copy of the release of information form, the argument for the release of information form, and an open records request if I can find one that I can send. And then I think that's it. And then we can talk about doing another one sometime soon. I hope that was helpful.
That's fantastic.